Yes, Mr. Solomon.
May it please your lordships, I, together with Mr. Platts-Mills to my left, represent the appellant, and Miss Ferber, King's Counsel, to my right, and Mr. Welch represent the respondents to this appeal. Mr. Welch and Mr. Platts-Mills both appeared at the levels below before the District Judge and Circuit Judge respectively, and I gratefully adopt Mr. Platts-Mills' excellent appeal skeleton argument. My Lord, on this appeal, on our appeal, there are effectively two issues. The first is whether the judge erred in holding that Geeks had a legitimate business interest in the clawback provision, and the second is whether the judge erred, whether the judges below erred in considering that the clause was reasonable. Because of the respondent's notice for this appeal in the Court of Appeal, there are two further issues. Firstly, we have said that this court shouldn't entertain the respondent's notice at all on the basis that, amongst other things, there's no jurisdiction or it's an abuse. But in any event, we say it's wrong that it was open for the judge to find, as he did, in a way that was not attacked on appeal, that the clause was a post-termination restraint. So with your lordship's permissions, I'm going to address the court on those four issues in that order. I'm going to start...
Well, we have thought about this. We don't want to spend too much of the day on the jurisdiction question, really. I see the force of what you say. The case wasn't run in this way for the employers at first instance. They tried, but too late to raise it on first appeal. But it's an important point of principle. If underlined several times, then it's dispositive of the case. As I understand it, Ms. Ferber will tell me if I'm wrong, the respondent's notice point is the restraint of trade doctrine doesn't apply at all. Is that right, Ms. Ferber?
My Lord, that's right. I mean, there is one thing with trepidation that I will correct in the way that you've described the position. This point was run at trial.
Right.
Before the Deputy District Judge, trial judge. It was lost, but the claim overall was dismissed on the basis of the legitimate interest and reasonableness points being won. And it was, as I understand the objection to the respondent's notice to this court, the point being made is that a respondent's notice should have been, the respondent's notice point should have been run in the appeal below.
Oh, I see.
But there isn't an issue about the point not having been taken at first instance. It absolutely was.
But that is what you say, that the restraint of trade doctrine doesn't apply at all.
That's right.
And it wouldn't apply if the provision had been that you have to repay the whole £8,108 as a lump sum. Simple application of summary judgment, bang, bankruptcy proceedings to follow. Simple as that.
This was a debt claim. The debt claim would have, if there wasn't a restraint of trade in that clause, there were other arguments which were also dismissed about penalty clauses, that would have left a money judgment before the district judge, deputy district judge, for the debt.
Yes.
It wasn't yet at the stage of a statutory demand or anything like that, or summary judgment, but yes, absolutely. The debt would have been payable if that point had been won at the first instance.
Right, thank you. Well, Mr. Solomon, unless you really want to try to persuade us that we shouldn't go down this road at all, our provisional view is that we should allow Ms. Ferber to make that argument when the time comes, and that you should certainly address it on its merits. But when I granted permission to appeal, I gave a time estimate of 1 day. It would have been better, I think, if when the respondent's notice was put in, the employers had asked for more time to be allocated. But anyway, we only have one day.
My Lord,
We'd rather spend it on the whole on the law of restraint of trade rather than on jurisdiction.
I entirely agree with your lordships. Obviously, your lordship's indication I'll do whatever your lordships say. But first, I'm confident that we can get this done in a day. Ms. Ferber and I have agreed between us the timings. I don't think it's going to be possible for, subject to your lordship's approval, for judgment to be given today, because we've got a lot to get through.
No, don't worry, we're not going to give judgment today.
Fine. I mean, the provisional timings we have agreed, subject to approval, is 10:30 to 12:45 for me opening the case. 12:45 to 1, assuming the court will rise at 1 and sit again at 2, and 2 till 4 for my learned friend Ms. Ferber to respond, and then me to reply 4 to 4:30 if I need that.
Yes.
I'm grateful. Can I just say this? What Ms. Ferber has said correctly and brutally encapsulates the respondent's position. We can reclaim this debt, and it's nothing to do with restraint of trade. We say it doesn't have any impact on the, as a disincentive to the employee's ability to compete with us. Nothing to do with that, it's just a debt. Fine. I will deal with that head on, my lord. But in terms of can I just say, I'm going to spend 2 minutes, if I may, on the respondent's notice point.
Yes.
What happened on appeal to the circuit judge was that the respondent was late in putting a respondent's notice in, and just before the appeal did so, and the position on appeal was that the judge said to the respondent, you want to take this point, you're going to have an adjournment. And the respondent said, well, we're not going to take the point. And the judge said, well, I will therefore have to approach this case on the basis that I am bound by the judge's original decision. And the respondent agreed that, my lord, on restraint of trade. That's
the doctrine applies.
Exactly.
Yeah.
So, my lord, for your lordship's notice,
It's paragraph 8 and 9, isn't it?
Exactly. 8 and 9, page 35 to 36, tab 5 of the core bundle. I offered, the top of page 36, I offered Mr. Welsh an adjournment. He declined. The effect, as Mr. Platsmill submitted, Mr. Welsh accepted, was that I had to proceed on the basis of the judge's finding the cause of restraint of trade. And so the respondent had the opportunity to seek an adjournment, to run a Denton argument, to spend money, because it was an out of time respondent's notice in respect of which Denton would apply, to spend money and time dealing with that, have the possibility of losing, to pay the costs of the appellant in having the unnecessary adjournment, perhaps pay the cost of the appellant in running and losing this point at appeal, but abandoned that and just said, we will take our chances. So we say, my lord, for the reasons we've set out, and I'm not going to go into any greater detail than what's in our skeleton argument, we say that, first, that doesn't engage the CPR properly, so that there's a jurisdictional question, and secondly, it's an abuse. So there are points of law in respect of the way in which the respondent has approached this case, which it is relevant for, we say, for the court to deal with. And although it's quite right that your lordship granted permission on the basis of our appeal, saying that that raised points of public interest, and with respect, that's right, we say this point on the way in which the respondent has conducted itself is also a point of public interest, and a party should not be able to effectively treat a first appeal as a nullity, abandon its position that it had there and that the circuit judge was bound by, and run the arguments again in this court without having to bother with a Denton application or costs or the change in circumstances between the parties, because, for example, if my client knew there was a different point being run, it might have taken a different approach, and there are obviously different factors, for example, in terms of settlement floating around. That has all gone. So I'm not going to say any more than that, my lord. For the reasons in our skeleton argument, we say that's an abuse and it shouldn't be permitted at all. But can I make one more point, my lord? I know you're about to say something.
Yeah.
what this court could do is de bene esse, hear the arguments on restraint of trade and come to a view, having heard arguments, which would meet the public interest point, but also deal with the jurisdictional and abuse point as well. Because we say on these facts, although the court can and should give judgment on whether or not this sort of clause is a restraint of trade, and that's a point of public interest, we say that shouldn't assist the respondent on these facts.
Yes. Well, if we're going to hear the argument on the respondent's notice point, it would be de bene esse. At the end of the day, in judgment, we could do anything, including say, on reflection, we should never have allowed this point to be raised or whatever. Yes. But so, if you can proceed on that basis,
I will say nothing more about it.
No. Right.
Could you just tell us where in the Deputy District Judge's judgment he deals with this point? With the question whether the restraint of trade doctrine applies at all. I was slightly deflected when it says the first point is whether there's a legitimate interest. So I rather thought it wasn't dealt with.
Yes,
perhaps it is.
So I am going to go through the.
All right. Well, when you get to
no, I will. I'll deal with it in terms, my lord. But the short answer is, he says in a couple of places, if I need to decide it on balanced probability, it's a post-termination restraint of trade. But the starting point is that he says he addresses the question of legitimate interest before making that conclusion. So what he'd had, and I can show you where in the bundle these are, what he'd had is lengthy arguments on the question of restraint of trade, and those are all in the skeleton arguments. And he says in terms, I'm not going to set out every single point that has been argued before me, but it's clear that he came to the conclusion that there was a restraint of trade. And that's clear, my lord, not least because the late respondent's notice against that decision was on the basis that the judge was wrong to find that there'd been a post-termination restraint of trade. And that's at the back of the supplemental bundle. I can take your lordship to that as well. But can I come back? I will address your lordship in terms on the paragraphs where he...
Yeah, by all means, of course. Yeah.
I accept that the district judge's judgment isn't as straightforward to read as it might be, but I'm not going to criticise the judgment. We're not taking a point on that in this court. We're dealing with the substance.
Right.
So what I plan to do, my lords, is take your lordships briefly through the relevant contracts and make submissions on them as I go along, and then show your lordships the two judgments, and the submissions I make on legitimate business interests and reasonableness thereafter will be much shorter because I'll have made a lot of the points of substance already when going through the documents. So the relevant contracts can be found in the supplemental bundles. Behind tab 5, there is a document headed Contract of Employment, and behind tab 4, there is the document headed Contract of Training Investment, which effectively is the clawback provision. They were both signed on the same date, on the 15th of March 2019, and appear to have been a combined suite of employment contracts. Going through these documents and just drawing out some of the key provisions, if I may, looking behind tab 5 at page 30 of the bundle, your lordships will see that the commencement date, 18th of March 2019, so a couple of days after it was signed, and the salary was 18,000 for the first year, going up 2,000 a year for the following 2 years. That is a very low salary. It's below the London living wage and UK living wage, as set out in the skeleton argument with the information in the supplemental bundle. And
how much was the national minimum wage in 2019 on annual basis? It's a bit less than 18,000, but not startlingly less.
I can tell your lordships the answer. It's behind tab 11, my lord. It was page 76. It was £10. I beg your pardon, 83.
Page 83.
Sorry, I've got the wrong page. No, Junior's told me correctly. 83, page 83. That's £8.21 an hour. What's that? Is it 1819? So it's £7.83. It's the yes, it's the penultimate row on page 83, and we'll work out the annualised salary for that as well. My lord, at page core bundle tab 16, page 172, paragraph 43, we address, my learned junior in his skeleton argument addresses the issue of amounts of London living wage and UK wage and works out the sums there for those two figures, but we'll do it for national minimum wage as well, my lord. On any view, it's a very low salary, and one of the points constantly emphasised in the case law, and if I may flick from time to time to the authorities bundle and show your lordships the decision of this court in Quantum, which summarises very helpfully some of the key points about post-termination restraints. If I can show your lordship that case in the authorities bundle at 1261, that's within the case of Quantum. It is tab 46. At 1261, the court starts dealing with reasonableness, and at 64 and 65 deals with its summary. At 64, the penultimate line highlights that the absence of independent legal advice for the weaker party may be relevant, and then at 65 sets out a number of points in the summary, 10 sub-points. If I can just highlight at 65.7 on page 1263, the Court of Appeal says factors to be considered when assessing reasonableness between the parties include the character of the business and also relevance of consideration for restraint. Pausing there for a moment, this was a worker paid almost as little as you can pay a worker or employee. Inequality of bargaining power, I'll address your lordships on that shortly, but this is plainly, on any view, this is, for this contract to apply, the employer would have known that the employee does not have skills. That's why they are paying, the employee is obliged to pay for the sort of training that Geeks is providing, and I'll address your lordships on that. But it's low-level stuff. It is a standard form of contract for Geeks. Thank you. And whether the restraints operate during or post-contract is relevant. I'll address the court on that and the surrounding circumstances. My learned junior, very effectively, my lords, has worked out that the national living wage at 19 to 20...
National minimum.
National minimum wage. Sorry. At 19 to 20...
It's the national minimum,
Yeah.
£8.21.
Thank you. For 19 to 20 was £8.21, times 260 times 8 is 7,076. So just
17.
But it was 1819, not 1920. That's when he started.
Well, it's March 19.
Sorry, what was the figure
The
again?
numbers in paragraph 43 are about the year 1819, so we've got to compare like with like.
Well, if Mr. Platts-Mills could check this in the course of the morning, the
so
the
it's-
figure, I would like the exact figure, but it's somewhere like that, but don't spend time on it
Yeah.
now.
I think the point is that even if it was the lower figure on the 18th of March 2019, within less than a month, it would be the figure for the next year.
Yeah. Yeah, and on any view, it's only if it's above, it's only just above. So the point I was, maybe the overly strained point I was making to your lordship, is that consideration is a relevant factor that the court can take into account when assessing reasonableness, and this is as little consideration as you could pay, and there is a massive inequality in the bargaining power of someone starting out at the beginning of their career as against a employer contracting on standard terms.
The consideration for the restraint is not the salary, is it, but the training?
It's the package, my lord. The consideration for restraint is the entirety of what was being given. It's not suggested that there's separate consideration for the clawback provision. But even if that's right, if all that the employee was getting was that training, we say that is very limited consideration indeed. And because of the way in which the clawback provision was worked out, the amounts are massively disproportionate to what is being given. So the amount of being clawed back of just over £8,000 is just under half the gross salary. And the training provision is, and as I will make submissions to your lordship, limited and of questionable quality. And even the judges below were unable to assess with any certainty quite what it was that was being given. For example, fire drills were alleged by the respondent to be included in training at one point, which was rejected by the judge. But I will deal with that. I'll deal with the judgment head on, my lord. Just carrying on going through the contract, if I may, for the moment. At clause 5. At clause 5, on page 32, there is working hours. There's a requirement of 5.1 to work for 39.5 hours per week, and 5.3, the parties contract out of the working time regulations. Clause 7 deals with exclusive employment, and 7.1 deals with the fact that the employment is an exclusive and full-time occupation, and the employee cannot work for any other person or organisation without written consent, or at 7.3 over the page have any interest in any business. An interest, of course, pursuant to Egon Zender, includes any shareholding. This is relevant, my lords, because as was set out in Quantum at, and I hope that your lordships page with Quantum on the authorities bundle is still open at 1263, at 65 little 5 on page 1263, the court is entitled to consider whether or not a covenant of a narrower nature would have sufficed for the covenantee's protection. And of course, if that's right, the court is entitled to consider whether any restraint is needed at all. So here, there is an obligation to work exclusively for the employer. If it's a pre-termination restraint, which I think is floated by my learned friend in their argument, then there's already an obligation not to be able, that you can't compete at pre-termination. So that will impact on whether a restraint of trade is needed in any form. Clause 8 deals with termination. 8.1 allows for termination.
You keep going back and forth to quantum.
Sorry.
We're back on the contract.
I'm sorry.
That's all right.
I will. If it's unhelpful, I'll make my submissions on quantum in one go. But these points quantum impacts on each of these points. So if I can, I'll ask your lordships to keep that open. Or I can just make the point from quantum without your lordships having to look at it. Clause 8.1 is a notice, termination and notice clause. And the first 6 months are the probationary period. During the first month, either party can terminate on 1 day's notice. And after that, 8.2, after a month, either party can terminate on 1 week's notice. Those are the statutory minimum notice periods. So there couldn't be any less notice. And that's what the company has opted for. If it's right that stability of the workforce is something Geeks cares about, and that seems to be one way that it puts its case following the appeal, although not at first instance, one would have thought an easier way of ensuring stability of the workforce is simply having longer notice periods. We say that stability of the workforce isn't about individual employees at all. It's about the ability of an employee who's left or otherwise to poach his or her former colleagues. But the appeal judge below said the clawback provision is actually about stability of the workforce, and Geeks has now latched onto that assertion from the appeal judge. Of course, the court, as I've read out, is entitled to consider whether or not a narrower covenant would have sufficed, but you don't need a covenant at all if all you're trying to do is keep the employee employed. The problem for Geeks with having a longer notice period is that you'd have to pay for that, and that might really be the key why it doesn't want to do that, and why instead it wants to recoup a sum in the clawback provision as a means of preventing competition. Over the page at page 34 in the bundle, still in clause 8, there is an important provision, 8.10, and this provision allows the company the right to recover the cost of formal training courses or conferences that you attend or undertake at the company's expense in the 18 months preceding termination. The company will pay for such courses as a career development loan. If your employment comes to an end other than by means of a company-instigated reduction in workforce, I understand that to be some form of redundancy process, you remain liable for the return of the company of the fees incurred for such training course and the cost of the course material which have been incurred by the company. To be calculated at full cost less an 18th of a full month following completion of the course or training. So that is a right for the company, subject to being dismissed for redundancy, which allows Geeks to recover specific expenditure incurred in training or going to conferences for career development for the employee. That is separate and distinct from the clawback provision in respect of training. So,
do you say that clause 8.10 is restraint of trade?
No, I don't. I'm not advancing any argument about that. It hasn't sought to be enforced, and this wasn't.
No, I understand that.
I'm not suggesting, my lord, that if a company has a specified expense, a liquidated amount that it says in advance it will pay for a specific training course, and upon termination it seeks to recover it, that could not be justified. It may or may not be a restraint, but it is probably reasonable. Lots of companies have clauses like this, but the question of whether or not this was a restraint simply wasn't considered. In fact, on the contrary, the judge said that this clause wasn't relevant at all. And when I go through the judgment, I'll show you where the district judge said that. It's paragraph 21. But at Core Bundle 8, page 102, I'll show your lordships that. But we say that can't possibly be right, because this clause allows recoupment of liquidated sums at the same time as there is a clawback provision allowing for recoupment of some form of alleged pre-estimate of loss. And why, we say, do you need both? You simply don't. The clawback goes way beyond specified expenses and relates to what we say is unevidenced amounts, in fact unevidenced and exaggerated amounts which can't possibly be justified, and in fact weren't justified before the judges below.
I mean, whether they're justified is a separate point, but they're dealing with different things, aren't they? So don't you have to ask the questions? Are they a restraint? Are they a legitimate interest? Are they reasonable? Separately in relation to the two clauses, if it arises.
They're both dealing with training. So clause 8.10 is about career development and training courses. And
well, that's dealing with external training, and the training contract's dealing with internal training.
The training contract doesn't say it's only limited to internal training. It says it's a training cost. It doesn't include external training in the specified costs. But my submission is this: if a company says there are specified costs that it will have to incur because of an employment, there are ways of dealing with it that aren't necessarily and are less intrusive than the clawback provision. But what the judge was wrong in doing was saying that this clause 8.10 wasn't relevant at all. This clause 8.10 has to be, the reasonableness of the clawback provision has to be analysed in the context that the employer already has a mechanism for reclaiming expenses incurred in training employees. So that's a factor which will impact on reasonableness. And the settled law is that other relevant clauses and simpler ways of achieving the same outcome are matters relevant to a judicial decision. The other clause which we say is relevant, my lords, is clause 17. And again, this clause was said not to be relevant by the district judge and not commented on appeal. Same paragraph 21 of the judgment. Now, these are the post-termination restraints, and these weren't considered at all below. In fact, were held to be irrelevant. 17.2 is the operative part of page 37 of the bundle. 17.2.1 and .2 are the non-work for clients and non-solicit clients provision. So these are ways in which Geeks protects what it might be its legitimate client relationships. That is a recognised legitimate business interest. And 17.2.3 and 17.2.4 are non-solicit or what employment law is often called non-poach provisions in respect of other employees, protected persons. And point 4 is a non-employment or assisting in employment of a protected person. So point 2, point 3 and point 2.4 respectively protect Geeks from a former employee for a period of 2 years. You can see the restricted period is defined at 17.1.6 at the top of that page, from either trying to poach or employ a colleague. And the definition of protected person, back at page 36, is very broad, and it's any person who in 4 years prior to termination of your contract was employed by the company and with whom you had dealings, who had significant knowledge of and or contact with clients or detailed knowledge of confidential information belonging to the company, who would be a significant loss. So it's a broad definition of protected person. To the extent these clauses are enforceable, these give huge protection to Geeks in respect of the recognised legitimate business interest of workforce stability. What is not addressed in Geeks' pleadings or evidence, or in fact in any document at all, or in any of the lower judgments, is why additional protection for workforce stability is needed over and above what we say are these draconian post-termination restraints already in place. So that's the employment contract, and may I then turn to the contract of training and investment, which is behind tab 4.
I suppose the more draconian they are, the less likely they are to be enforceable, and therefore the need for some other form of protection.
Well, that if that's Geeks' argument, my lord, that's a very ugly argument with respect. I'm sure that's not your lordship's intention to put an argument in an ugly way. But what the question is not, are my other covenants so draconian as to be enforceable, so I have to rely on this otherwise draconian and unenforceable covenant? That isn't the right question, my lord. The right question is there a different way in which the same ends can be met in a more reasonable manner? And that's what Quantum is assessing. And that's what page 1263 of the appeal bundle Quantum says. The court is entitled to consider, little Roman 5, entitled to consider whether or not a covenant of a narrower nature would have sufficed. So it's not looking at the actual covenants, but looking at a conceptual covenant. So I hope that answers your question. But what is behind your lordship's question, namely, these covenants don't look enforceable, so therefore Geeks are wide open, that underlines, my lord, the draconian nature of the contractual relationship between the parties and underlines the inequality of bargaining power. So turning, if I may, to the contract of training and investment at tab 4, page 26. Now, let me start by saying this is a very unusual agreement, and whether a clause is unusual is a factor in assessing reasonableness of a covenant. It's not suggested, for example, at any stage that this is an industry standard or that it's needed generally in the industry or in any industry. And the examples relied upon by Geeks for justifying recoupment of expenditure, in their skeleton argument for this court, namely Credico, Lambert and One Money, and I'll address your lordships on those when I come to deal with reasonableness, legitimate business interest, sorry. Those two cases, those are the two cases relied upon by Geeks. They are both commercial agency contracts, not employment relationship contracts. So to the extent, and we say that's wrong anyway, to the extent the court is saying spending money is a legitimate business interest, we say that can never be right. It can never be right, we say, in the employment context. And if Geeks remains of its position that the legitimate business interest it's seeking to rely on in supporting the restraint of trade clause is financial expenditure, we say this case fails ab initio.
Well, let me just go back to clause 8.10 of the employment contract, which
Yes.
showed us that if we send you on external training conferences and pay fees in the 18 months prior to termination, we can recoup those disbursements from you. That's a type of clause I've seen quite often. One would think that, subject to maybe arguments about quantum if it was an extraordinarily expensive course, but in principle such fees are recoverable.
It may well be, my lord, that that such a clause could be a restraint of trade.
Yes.
But it is likely, depending on the terms of the clause, that it is justifiable as reasonable. And that's why it's very rare.
Yes,
for such
you've jumped over. What is the legitimate interest being protected when such a clause is enforced, if it is?
It may well be that it's not a justifiable restraint of trade at all on that basis. But if the clause is set up in this way, my lord, that an employee has the option of going on a course while at work and chooses that option, knowing that she or he has to repay that expense if they leave in a period of time, that may or may not engage the restraint of trade doctrine. If it does, it would presumably be related to stability of your workforce, that an employer is entitled to promote its employees, promote the employment and training and experience of its employees while they're employed. But one would assume that it's justifiable and reasonable. If, on the other hand, an employer chooses, for example, to say, you're going to go on a fire drill and we're going to make up the time cost for any of your line managers, which is unrelated to the actual expense of employing them as line managers, and you don't have any choice in this, and we're going to recoup that notional expense as a lump sum, then that is unjustifiable and simply a prohibition on competition. And I use those examples because that's precisely what the clawback provision is, my lord. So looking at the clawback provision, on page 26, the first heading, introduction, says that you, Mr. Watts, have agreed to meet the training debt cost, which is the estimated financial cost of supporting you in this position. And training debt cost is defined over the page at page 27 as, at the bottom of the page below the lower whole punch, training costs accumulated during the first 6 months of your employment or pro rata if your employment ends before completion of 6 months. So, as your lordships have seen, you can be dismissed on 1 week's notice in the first 6 months after the first month, but if you're dismissed, you still have to pay back the training cost. And it's expressed in this way. You agree to repay the debt via a combination of the following repayment methods. The first is by working. So at the bottom of 27, for the first 6 months and for another 6 months, you'll continue to receive training, but the value of your contributions to the company balance your additional training costs. And then, over the page at 28, once you've worked for 12 months, in consideration of the benefits of your employment to the company, the training debt cost will be written off, deemed to be paid by 1/18 per subsequent complete month of full-time employment until it reaches 0, less absences. But, under the next heading, if your employment ends prior to completion of the repayment of the debt, you pay the outstanding sum with monthly amount of 1/18 of the original training debt cost until paid in full. And there's a 5% reduction if you pay it promptly. So it applies if the employment ends. So unlike the clause 8.10, which doesn't apply in a redundancy situation, this training debt cost applies whenever. So even if the employee is dismissed on grounds of redundancy, they have to repay. Or the company dismisses you for any reason or none before you have rights for unfair dismissal. And it's not only about recovering money from someone when they leave to get a higher wage. That's significant, as that seems to be what the judges, both judges below, understood, and I'll address your lordships on that in a moment. The judges below did not consider what the parties objectively, when entering this contract, would have known, which is the relevant test is simply that it's recoverable if the employee's employment ends. And of course, as Quantum and many other cases underline, the time for considering reasonableness is the time of making the contract. So post-contractual facts and matters are inadmissible for determining reasonableness. Training cost calculations are set out at page 26, and those add up to £8,108, which is quite a specific amount. But there was no evidence put forward by Geeks as to how that was reached, and the judge concluded, and I'll take you to it in a moment, paragraph 28, that wasn't fatal.
Sorry, I don't. You said there was no evidence put forward by Geeks as to how that was reached.
Yes.
Surely.
Oh, you can see.
It's there in the table.
You can see here the amounts.
Yeah.
But the problem for Geeks, my lord, is that the hourly cost for mentors bears no relationship with the amount that it was paying its employees. Yeah. So we have the employment contracts in the bundle for the mentors, and they're being paid just slightly more than Mr. Watts was being paid. So the employment hourly rates would add up effectively to 124,000 a year or something like that of that order. It's all in our skeleton argument. But Geeks were in fact paying their employees 18, 20, 22,000 pounds a year. These are the mentors. I'll take your lordship through the facts in a moment, but what that shows is this asserted pre-estimate of loss of nothing of the sort, and Geeks at trial were entirely unable to explain how these figures were reached. What they said, and I can show your lordship the letter where it said, was that we did work it out at the time, but we haven't got any documents showing that, so we can't help you anymore. What tab? Thank you. My learned junior reminds me, it's tab 8, page 50 of the bundle, of the supplemental bundle. You can see a letter from Geeks because of a disclosure obligation, and pursuant to the order in the middle of the page, we attach raw data. We're not able to provide documents showing historical analysis of the cost of the business associated with providing data. That's because although an analysis was undertaken by the company directors to reach the calculations, and this was not documented. Therefore, there's no record. That was the position at trial. It was worked out by my learned junior what the costs of what the hourly rates meant for the actual employment cost to Geeks, but these bear no relation to the salaries they were paying the people who were mentors. Mr. Watt's own salary in the training course calculations forms part of what is being reclaimed. It's 1.5 times his salary divided by 12. So he has to pay his own salary times 1.5. And there are other costs, employment costs spent on study and practice activities. And if you turn over at page 27, you'll see the note 1, which is explaining time spent by mentors for training, includes things like answering questions. So this is a cost that an employee has to repay their employer. If you ask your line manager a question, that's the sort of thing you have to pay for when you leave. Or correcting mistakes that you make. These are the sort of things that all line managers do for all new employees, especially new employees at the start of their career. And that's why, presumably, Geeks were entirely unable to provide any basis for explaining how their figures worked, because this sort of clawback provision is simply not suited for recovery of a liquidated sum. Then over the page, on page 28, there is a section on which Geeks place great weight, a section headed for the avoidance of doubt by the top hole punch. And that makes it clear that you will not be in breach if you choose not to work for the company after any period of time, presumably subject to notice being provided by the employee. That would, obviously leaving without notice would be a breach, but I think that means you're not in breach if you compete with us per se.
And presumably to ensure that the penalty argument
Exactly.
is not available.
Exactly.
Yeah.
Exactly, my lord. And the second bullet point is nothing in this agreement is intended to restrict you from pursuing other employment or trading opportunities. Presumably, one would imagine, to try and assert that the restraint of trade doctrine doesn't apply. But it is settled law, I can take you to MIT Marshall and NM Financial Management in this court if you want me to, that a term that has the effect of being a disincentive to competition can amount to a restraint of trade. Perhaps I can just show you that point in Marshall. This was an appeal from a deputy judge called Sumption. I don't know what happened to him, but his decision was upheld by the Court of Appeal at page 951 of the bundle. And this is a judgment of Lord Justice Millett, as he then was. So it's a very powerful case. Sorry, an appeal, authorities bundle.
Sorry.
No, it's my fault.
30.
I'm grateful. Yes, tab 30. And I'm simply showing the court the point of paragraph E. And Justice Millett says restraint is imposed in the form of condition. It's settled law. There's no difference in this context between a contract by a person who will not carry on a particular trade.
You've dropped your voice.
Sorry, page.
Sorry.
I'm sorry, it's page 951.
Yeah.
And I was reading out the paragraph at E, my lord. It's settled law that there's no difference in this context, between a contract by a person that he will not carry on a particular trade, which if valid would be enforceable against him, and a contract that if he doesn't do so, he'll receive a benefit to which he would not otherwise be entitled, which if valid would not prevent him from carrying on the trade, but merely result in the loss of a benefit in question. And the court looks at the substance of it rather than any labels the parties choose to put on it. At the bottom of page 28, there's a section dealing with disputes as to whether or not the individual was dissatisfied with training. And at the top of page 29, the final section asserting that as a direct benefit of the company's investment in your training, the market value of your skills would increase, exceed your salary, it's asserted. Whether that's right if you're dismissed within 6 months is not clear, as the contract contemplates the possibility for. And then by the top hole punch, it asserts that you acknowledge you're entering into this agreement freely and after evaluation of other career options, having had the opportunity to obtain legal advice and make representations on it. The judge found, as a matter of fact, that Mr. Watts was given this document the day before he was asked to sign it. I'll show you, Your Lordships, where the court says that. But the court is entitled to look, as a matter of reality, whether someone who is about to start work on a very low paid contract, who gets a contract the day before he's asked to sign it, is actually going to be able to take legal advice on the enforceability or otherwise of this sort of clause. It's not suggested that this clause has ever been amended previously by Geeks following anyone ever having taken legal advice on it before. It's quite a specialist bit of legal advice you'd need to take on this sort of clause, and one would imagine it's quite costly and unaffordable for someone in what Geeks knew were the position of this.
But the Deputy District Judge found that the documents were in plain English. He discussed them with his family.
Yes.
And had full knowledge of the consequences should he choose to leave. So
Yes.
he knew and accepted the worst case. Legal advice, which might have told him some of it might not be enforceable against him, could only have made his position better. But he knew the worst case and accepted that.
Well, my lord, I accept that. What the approach, I accept that's what the district judge said. The district judge, in my submission, was approaching it on the basis that you just look at the contractual terms. If you can read them and understand them and know what the effect is, then you're bound by them. But the restraint of trade doctrine imposes an obligation of reasonableness, and it obliges the employer to justify the clause. And it is settled law that the availability or otherwise of legal advice is a significant factor when assessing reasonableness. So it's not simply that an individual has understood the terms, but if they understand that the terms could be unenforceable or that they could have an ability to negotiate, that puts them in a different position. I'll show
But
the court.
it looks from the judgment as if the judge was going point by point through the points which were raised.
Yeah.
Because that's what he says, the first issue raised, etc. Was availability of legal advice raised as a factor?
Yeah. Yes. Yeah. Yes, it was.
Yeah. Okay.
And I'll show your lordships where that was raised. I'll address it. What I'll do, if I may, is I'm taking slightly longer than I wanted to. Go through the pleadings and the judgment, and then make submissions on legitimate business interest and reasonableness, just to tie these points together. But hopefully, I've been making quite a lot of them as I've been going along.
I mean, just that as I see it, anyway, on appeal, there may be a difference between a judge failing to deal with a point which was raised and failing to deal with a point which wasn't raised. That's why I asked the
Yes.
But you'll show me in due course.
I will. Yeah, I will. So turning briefly then to the pleadings, these are in the supplemental bundle. The amended particulars of claim is behind tab 15, page 98. It's a debt claim, quite simple. Supplemental bundle, tab 15, page 98. He resigned, there's a contract, he owes us the money. The defence, I'm afraid, is in the core bundle, behind tab 10. We didn't want to make it simple for the court, my lord, so juggled the order up of everything. Behind tab 10 of the core bundle, and your lordships will see, I'm not going to go through the defence in detail, but your lordships will see it's a lengthy document. At page starts page 125, and then at 133, there's a heading at 41, unlawful restraint of trade, so this point was taken. And at 42 it's said to be unenforceable and a disincentive on competition. At 43, again, unenforceable. The particulars of claim were amended after the defence, but the particulars of claim did not address the restraint of trade issue at all. So there's no legitimate business interest pleaded and no justification advanced in the pleadings by Geeks. The consistent position when it came to trial by Geeks is the one that they have taken now on legitimate business interest, which is in their skeleton argument in the core bundle behind tab 17 at paragraph 49. It's page 187. Oh, supplemental bundle. No, it isn't.
Or is it?
No, it's the core bundle. My learned friend assumed normally correctly that I was wrong, but on this occasion that wasn't right. It's behind tab 17 of the core bundle.
Yes.
And I'm at page 187, paragraph 49. And this is what was argued at trial. The legitimate interest at trial was to protect the investment it made in taking on employees into training roles. And it's right that that was argued at trial, and I can give you the references if you want for the trial skeleton, but also the respondent's short note for objecting to permission to appeal for this court as well. It repeats that point. So that has consistently been its position. That is the legitimate business interest.
Well, what's wrong with that?
We say that protecting an investment, my lord, cannot amount to a legitimate business interest, and I'll show your lordships why in a moment. The appeal judge, as is rightly stated in this document, at paragraph 51, said in fact the legitimate business interest was maintaining a stable and skilled workforce. I accept that that might be a legitimate business interest, but that doesn't assist Geeks, because that isn't its case, but the legitimate business interest doesn't begin to justify the clawback provision. And this sort of restraint, this sort of interest, maintenance of a skilled workforce, is almost invariably enforced by non-poaching clauses. Don't poach your former colleagues, that sort of clause. Not, you may not leave and use your skills elsewhere, which is what this clause is. And that's how the judge, at first instance, determined it. And we say protecting an investment, which includes the investment of a salary paid to the employee, as you've seen in the cost, can, in order to disincentivize an employee from competing, can never be a legitimate business interest. So if I may turn to the judgment of District Judge Hope, that is behind tab 8 of the core bundle. Paragraph, just going through this reasonably swiftly, because I know your lordships have read it already.
This was, if I get this right, it was a 2-day hearing and judgment given on the second day after a bit of a gap, is that right? Rather than a reserve judgment as such.
Yes. The facts are dealt with at paragraph 12, page 99 of the bundle, about what the claimant does and what the defendant is employed to do. And then at paragraph 15 on page 100, there's a dispute about what happened about the contract, and there were casual meetings in early March, but on the 14th of March, Mr. Watts was given the clawback provision, and we know that it was signed the following day on the 15th of March. And then paragraph 16, which is the paragraph my Lord Justice Males read to me, that he was provided with the training contract. I think I'm wrong.
I was looking at a later paragraph, but this is recording the fact.
Yeah. And then paragraph 18 records in the bottom 4 lines of that paragraph that defendant's right to say there was no base documentation in support of the calculation of the recouped cost, and Miss Jessup, the Geeks witness, was not able to assist us with how that came about. And then paragraph 19 sets out how the training debt accrued. And at paragraph 21, page 102, the judge considered the employment contract. And the last 4 lines are important. The judge says that Clause 8.10 preserves the right for the claimant to recover costs of training courses or conferences, and Clause 17 had what is commonly termed as restricted covenants, but they are not relevant. So here's where the judge said those clauses which we place weight on are not relevant at all in this context. We say that's an error of law. They're obviously relevant when assessing the reasonableness of any restraint of trade, like the clawback provision. Paragraph 24 deals with what the judge took into account, and this is the training that Mr. Watts actually received. And 6th line down, you see the judge says, I've gone through the records. It seems to me certainly there's scope for the meeting section not to be construed as training. So this is, as I understand it, Geeks have put forward evidence of what training Mr. Watts had received in order to justify their covenant. And this is the judge recording it. In some regards, obviously a fire drill would not constitute training. The training apparently included fire drills on Geeks' case. But it seems to me that the majority of the entries in there, given the status of the trainee, would have been learning on the job, because it seems to me it falls in the description of training you're doing a meeting with other people whilst you're in a training capacity, that's the kind of training envisaged, not solely but partially. So just being in a meeting and doing your job amounts to training which enables Geeks to reclaim it. Now, a couple of points here. First, what happened as a matter of fact is irrelevant to determining reasonableness, because you look at the position as at the date you enter into the contract, not thereafter. So the reasonableness of a covenant isn't impacted by the fact that you might get no training or lots of good training. Secondly, however, what this shows is that it's incredibly difficult to assess this type of training being given by Geeks. It's a nebulous, undefined concept, and it's particularly inappropriate to have it formed into a liquidated debt which Geeks reclaim. Paragraph 28, the judge is saying that he accepts the evidence from the claimant, that the evidence from the claimant could have been better in terms of providing evidence from mentors or timesheets. I form the view, based on the way in which contemporaneous documents go back and lack of complaint, the defendant broadly received what he contracted for. Might not have been what he wanted, it can't be right, subject the training contract to the type of forensic analysis the defendant asserts in the context where it can only be an estimate and some of the services are immeasurable. We say that's another error of law, that the sort of forensic analysis that it was subjected to by Mr. Platts-Mills is exactly the type of analysis which a restraint of trade clause must be subjected to. Going forward, the judge set out the general law on restraint of trade from paragraph 32 onwards.
Sorry, can you just, what is the error of law? Is it to say that you can recover where services are immeasurable, and that you say, as a matter of law, if you're going to claim these, you've got to be able to measure the value?
We say, yes, my lord, yeah, essentially, that if one of the points of reasonableness when assessing this clause is that the amounts on our case bear no relationship to any expenditure incurred by Geeks, and it is simply used as a significant amount to deter competition against Geeks. If, however, Geeks had been able to say there are these specific expenses which we've incurred, like, for example, the way in which it might have approached clause 8.10, then the position would be very different, and it might be much more readily justifiable and reasonable. But that's exactly the sort of forensic analysis which a restraint of trade clause must be subjected to. The courts have consistently said that restraint of trade clauses must be, especially in the employment context, must be analysed with anxious scrutiny in order to justify their reasonableness. And what appears to have happened here is that the employer just put some figures in a document, at trial was entirely unable to explain or justify those figures, and the judge said, well, that doesn't matter, because we're just working out a rough and ready assessment of your pre-estimate of loss. And we say that's wrong. You've got to be able, even at some basic level, to explain how your quantum is reached. And Geeks can't. It's simply the amount being almost half the gross salary is a huge amount and a massive disincentive against competition. So at 32 onwards, the judge sets out the law. There's a lengthy sections quoting quantum from paragraph 33 onwards, and at 34, page 109, the judge sets out Harker Sinclair at some length. These are two Supreme Court judgments dealing with restraint of trade. And then at paragraph 37, the judge assesses the legitimate business interest. As I've said, all parties have proceeded on the basis that the starting point of the judge is that the judge found that there was restraint of trade, and it's a necessary condition to assessing legitimate business interest for the judge to have come to that conclusion. And if your lordships look at paragraph 43 on page 114, the judge said he'd find it, if necessary, that it's a post-currency restraint of trade.
Well, I must say I'd read that as proceeding on the assumption that it was a restraint of trade, and then addressing the question: is it pre or post termination?
My lord, my submission is that's an unfair way to read this judgment. It is as my learned friend in her skeleton argument makes the point, you don't subject this sort of judgment to scrutiny like a statute, and you've got to approach it on a fair basis. The judge said he's taking into account the lengthy skeleton arguments by both sides, and both sides made lengthy submissions on whether or not the restraint of trade doctrine applied, and the judge can be taken to have understood that and approached it on that basis, and that's why he didn't deal with it in terms. He said restraint of trade, it was a post-termination restraint and dealt with legitimate business interests and reasonableness. That can only be on the basis that he assumed the doctrine did apply. Okay. I can give you the references for where the parties dealt with it in their skeletons if your lordship wants.
That's right.
And then at 37 and thereafterwards, he assesses reasonableness. At 38, page 113, the judge says it would be a legitimate interest for the employer to protect their interest if they spent money by employees doing the tasks they could otherwise do in training when they could otherwise have been doing other tasks. It seems to me overall that the answer to the loss of profit, legitimate interest argument is in
I don't understand that.
I beg your pardon?
I don't understand that sentence.
No.
This judgment on the whole is very well expressed, but I don't understand that sentence.
It doesn't make much sense, I accept that. I think what the judge is doing is attempting to justify the fact that he said a legitimate business interest is spending money, and he's finding support for that in Harkus. But that is wrong. That is certainly not what Harkus says. And then he goes on to cite Egon Zender in the same paragraph, and then at paragraph 39 says, when you consider these cases and the overarching principle at paragraph 70, I think that's paragraph 70 of Harkus Sinclair, which he quotes back at page 111, it's obvious that the legitimate interest is not only internal costs, but also the fact that if they, employees, leave without being bound by the covenant, it's depriving the employer of opportunity costs of having trained employees and or the use of trained employees' skills, which they've invested in, as opposed to having employ in their stead a skilled employee, which is going to cost them money. So the legitimate business interest is spending money on training instead of having to spend more money on trained employees. These, we say, are classic examples of what cannot be protected, and I'll show you settled law on that. Paragraph 40, the judge says, I do note in Harkus, albeit it's a different type of provision, a legitimate interest in that case was all about preventing a respective loss of profit arising from a professor seeking to evade an exclusivity agreement. That's simply wrong. Harkus Sinclair was about protecting confidential information in client relationships. And that's clear from the head note in that case. I can take you to it if you want, but my submission is that is simply wrong. And then the judge goes on. Having rejected that specific argument in relation to loss of profit, I conclude the defendant is seeking to protect a legitimate interest, which is that it retains employees, that it is invested time in money and training, so that if they then lose the benefit of training and go off to someone else at a higher wage. I think something went wrong in the grammar there, but what he's saying is the legitimate interest is investing time and money in training an employee so that they can't, and stopping them going off to someone else and getting a higher wage. If that's right, every person who gets training at work could be obliged to repay those training costs if they leave. Every solicitor, or every solicitor on a training contract, or more broadly, every junior member of staff who's shown the ropes, that's what this is, has to repay their salary times 1.5, plus all the costs, whatever they are, however they're made up, of the people who've told them how to do their job. We say that's against public policy, but most importantly, maybe not most importantly, in addition to being against public policy, it's not a protectable interest. Salary and the costs of employment are the fundamental costs of employing someone. That is at the heart of the wage-labour bargain that goes into every single employment relationship. This judgment undermines that quid pro quo in the employment relationship. And to the extent I need to go to high authority on it, it is directly contrary to the highest and longest standing authority in this area of law. So if I can show you briefly the case of Herbert Morris, which is in the bundle behind tab 20, and I would like to turn, if I may, to Lord Shaw's judgment at 556. This is a classic exposition of the point. The House of Lords from 111 years ago, which has stood the test of time rightly, because it's still a fundamental point in the employment relationship. I'm reading from the middle of the page. The judge refers to Mason, the great case of Mason and Provident, and then says, trade secrets, names of customers, all such things which sound in philosophical language are denominated objective knowledge. These may not be given away by the servant. There is master's property.
So I don't think you need, this is a famous paragraph, I don't think you need to read it out.
Can I just ask your lordship to read the next line? The man's aptitude, his skill, dexterity, mental ability, they're subjective and they're not his master's property.
Yeah. That
is precisely what the judge is saying is the interest here. It's the training which an employee has had. To the extent it needed affirmation, Egon Zender repeated this very passage in the Supreme Court. Paragraph 27, I'm not going to take your lordships to it, at page 1148 to 9 of the authorities bundle. You simply cannot prevent someone using their skills that they have learnt at work. That is not a protectable interest. Similarly, my lords, in Stenhouse, the Privy Council case, which is tab 23, at page 699 of the bundle, this is Lord Wilberforce. At D to F, Wilberforce says, 699, the accepted proposition that employer is not entitled to protection from mere competition from a former employee by means that the employee is entitled to use to the full any personal skill or experience, even if this has been acquired in the service of his employer. It's this freedom to use to the full a man's improving ability which lies at the root of the policy of the law regarding this type of restraint. And he contrasts that with what a legitimate claim for protection is, which must be based on, I'm reading from a few lines down, the employer's claim for protection must be based on the identification of some advantage or asset inherent in the business, which can be properly regarded as his property, which it would be unjust to allow the employee to appropriate for his own purposes. So you can't stop an employee using his skills and experience. My lords, that Privy Council case was relied on and applied in this jurisdiction by the famous Office Angels case in this court at tab 27. And if I can ask your lordship simply to look at paragraphs 20 to 26 for the principles set out there at page 726 of the bundle. At 21, it's for the covenantee to show that the covenant's reasonable in the interests of the contracted party and the public. 22, there's a distinction between vendor-purchaser agreements and those relied on by my learned friend when asserting legitimate business interests, and a covenant between master and servant. 23, in the case of contracts between master and servant, covenants against competition are never upheld, and the Herbert Morris case is cited. And that quotation is important because Lord Parker says, wherever such covenants have been upheld, it's been on the ground not that the servant or apprentice would by reason of employment or training obtain skill and knowledge necessary to equip him as a competitor, but he might obtain such personal knowledge and influences of the customers or trade secrets or perhaps of colleagues, justifying a stable workforce provision. So those are the differences. Paragraph 24, the subject, and this is the Stenhouse and Phillips quote, which I've already shown your lordship, and then paragraph 25, the employer has to satisfy the court that the restrictions are no greater than reasonably necessary. And 26, these principles make it necessary to identify with some care the advantage or asset inherent in the plaintiff's business, which it asserts can be regarded in a general sense as its property, and which it asserts would be unjust to allow the defendants to appropriate for their own purposes. So you can't appropriate an employer's confidential information, and you can't appropriate an employer's trade relations with its clients by stealing its clients, and you can't appropriate an employer's employees other than yourself. You can leave, but you can't go and use your knowledge of who the best employees are to take them and seduce them into leaving to go to your new employer. That is quite different from what is now asserted as a legitimate business interest, which is using the own training that you've got, appropriating apparently the amount of time that your line managers spent on you and your own salary. That is not an appropriation. It doesn't make any sense to talk about that as property of an employer, which can be the subject of legitimate business interest.
Well, that's why I was asking about the training course fees. I mean, it's pretty well established over the last 100 years that trade secrets are legitimate interests that can be protected. Customer connection within reason, and also within reason, covenants against poaching or
Yes.
for their employees. But yeah, if, as I think, training course fees must be recoverable in principle, then what is the legitimate interest which is being protected?
Yes. Well, it may or may not engage the restraint of trade doctrine at all. It may not, but that isn't necessary for this case. That is, clause 8.10 is not an issue. The clawback provision is, and that is a form of provision that is entirely separate. I've done my best, my lord, to address your lordship's question on that, but I will do better in this respect. I'll show your lordships in a minute the case of Hubble, where clauses like the clawback provision were considered by this court in the context of restraint of trade. And so, and these aren't, it wasn't talking about payments for courses that an employee has been on. But my submission is all that we need to show is that, well, I say that the respondent's bound by the approach it agreed to below, and it's not able to open up the question of restraint of trade at all. But if that's wrong, it's this case. The judge was right to determine that it was restraint of trade, and the judge certainly wasn't wrong in a way which allowed this court to interfere with that decision. And that once that position has been reached, it can't possibly be a legitimate business interest, and it can't possibly be reasonable. So I note the time, and I do want to deal with my submissions on all these points. I'm sorry, my lord. Hopefully I'm not sidestepping your question. I will come back directly to it because I'm going to address Hubble. But the judge at paragraph 41 and onwards dealt with reasonableness. He said the next issue is the oppression test arising out of pre-quantum authority. We say that's the wrong test. The correct test is the test set out in quantum. It's not to determine whether it's oppressive, but whether it's reasonable between the parties, as quantum says. At 43, as I've said, the judge says that he would find it's a post-currency restraint because the actual obligation to pay something only occurs after termination. In any event, having reviewed carefully the authorities post-dating those paragraph 18 claims, skeleton doesn't support the continued existence of the oppression test. So again, he's reintroducing the oppression test there. And then at 44, he says the main battleground is reasonableness rather than legitimate business interest. That's wrong. I've made some of my submissions on legitimate business interest. But 45, it's an interesting paragraph where he says there's an inequality of bargaining power that's agreed. There's an imbalance, but submitted the defendant's in an exceptionally weak position given his finances, opportunities, and being led down the garden path in the pre-contract dealings. In my judgment, there's no more inequality than any other employment relationship. He's an intelligent, educated man who wanted an opportunity. No one else would give it to him. He could have pursued employment in another industry. He received the documents in plain English and discussed them with his family in full knowledge of the consequences. That was the paragraph your lordship read me out.
It was, yes.
What the judge says is that this is no more unequal than any other employment relationship. So, for example, this employee is in the same position vis-à-vis a restraint of trade as any other employment relationship. My submission is that's plainly wrong. So one company can have one set of covenants, and they might be reasonable for the most senior person in an employment relationship, a well-paid chief executive, and unreasonable for the most junior person. Simply because they are both in an employment relationship doesn't mean that it per se that it's reasonable. The judge, in coming to the conclusion that it's no more unequal than any other relationship, didn't take into account the reality of the situation, the low pay, the fact that it's likely to be a first job for an employee, and considers this just in the same way as any other employment relationship. And we say, as I've said before, I think, that what the judge is doing is saying, you read the contract, you understood it, that's the end of it. But that is not how restraint of trade works. At 47, the judge deals with the fact that the employee could make considerably more money once he'd been in employment for a while. And he says, about 8 lines from the bottom, the evidence rather bears out that the penalty was affordable to the defendant, because we know that you're getting paid £18,000 and you have to work to pay off the debt further for 18 months, as opposed to leaving and getting a £12,000 pay rise. He's in a better financial position. That's, as a matter of fact, what happened. But that's...
You're not to know that at the time.
Exactly, my lord.
Striking the bargain.
Exactly. What you ought to know at the time is not the fact that you're going to get a better job, but that you might just as likely be dismissed by the employer. And that isn't a factor the judge took into account. Instead, he erred in taking into account post-contractual irrelevant factors. Paragraph 48, the judge says, what is essentially said here is that the claimant was able to terminate the employment contract as a week's notice, but the defendant wished to avoid being saddled with the debt. He had to stay for a considerable period of time. I do not find this fact to be of particular assistance because there was no compulsion, it's market forces. Now, quite what that means in the context of the judge having already found, as a matter of fact, that this was a restraint of trade isn't clear. It reduces to zero the effect of the inhibition against competition of the employee having to repay almost half his salary, just dismissed as market forces.
Sorry, where's that? Oh, 48.
Yes, sorry, my lord.
Yeah.
5 lines down in 48. 49. This is the point that I've made to your lordships already. My learned junior made below. The lack of evidence about the way in which the contract was drafted and the clarity about how the training was provided, it said, goes against reasonableness. That is right, it does. But as I found, the trainee contracted for what was broadly provided. That is the wrong assessment. It's not whether or not the contract was complied with, but whether the contract is reasonable. I've already made my submissions on that.
It may be that he is eliding cost and value in this paragraph.
Yeah.
He says that the defendant gets the benefit, i.e. the value of the training, but that does not necessarily answer the question, what did it cost the claimant to provide it?
Exactly.
And I think that was the point which
was advanced.
It looks as if the argument was focusing on...
Exactly. And my lord. My learned junior went into detail analysing the true cost of the mentors, which was nothing like the £60 per hour notional fee which the employer...
Yes, well, you've explained that.
Yeah. And then at 50, the judge says there's no demonstrable relationship between the period of service and the recruitment of the outlay. Except in this regard, there's no documentation to underpin the analysis, but that's not fatal. So it doesn't matter that you can't, that there's no evidence to support the Geeks position. And at 51, the conclusion is the true purpose. The conclusion is in the defendant's argument is that there's an inference that the true purpose of the clause is to prevent people leaving. The way I've looked at this is that if I find, as I do, there's a legitimate interest to keep those that the claimant has invested in training, this point doesn't assist the defendant. So the legitimate interest is stopping people you've invested money in from leaving. That cannot possibly be a legitimate interest, my lords. That can't be a protectable interest. That's a prohibition against competition per se, which all the cases say cannot be advanced. Then he goes on, if it's a legitimate purpose, the question is simply whether or not the second stage, i.e. reasonableness, is satisfied. The corollary, I can't say it, is what benefits were secured to the defendants. I'm not making finding contrary to 65.3 of Quantum. The fact they both benefited is a reason to allow it. 65.3 of Quantum, and it may be easiest just to turn back a few pages to where the judge sets it out. It's at page 108 of the same file we're in. This is where the judge quotes Quantum. That's the judge, the Court of Appeal saying it's no answer to the question of reasonableness to say that there have been substantial financial rewards on all sides. So that is the court saying that normally, often, an employer turns up at court and says, this covenant must be reasonable because we've paid the employee loads of money. And the Court of Appeal says, no, that isn't determinative of the reasonableness question. But that point makes no sense at all when analysed in paragraph 51. 51 is the judge saying both parties have benefited. It's not an assessment. 51 is simply a confusion of what the Court of Appeal in Quantum was saying. And the judge then says at the end of that, it's relevant in my judgment, the defendant has secured better employment because of that training and is in a better financial position he would have been had he stayed on in the claimant's employ. That again is plainly taking into account an irrelevant, inadmissible fact of what's happened post-contract. And then at the conclusion, go over the page at 52, the end of that paragraph is the judge saying 4 lines from the bottom, it's a legitimate interest of the claimant to wish to retain its employees. I imagine that word should be retain rather than attain. Retain its employees, that's not a legitimate interest. And it's not wrong in principle to incentivise them by not rising their wages, but by making them subject to an obligation to reimburse a training debt. They're incentivised, apparently, by having to repay a debt to prevent them using the skills they learnt at the claimant's cost to go elsewhere at a higher salary. So there are various points here. Again, the judge is emphasising that what the prohibition does is prevent the employee using the skills they've learnt. That is an absolute offence against post-termination restraint law. And going off elsewhere at a higher salary is an irrelevant post-contractual factor. So the whole series of errors in this paragraph, but that is reflected in the entire judgment. And exactly the same point is made in paragraph 53 to the extent it can be made sense of. If I can show your lordships quickly the appeal, my fundamental point is that the errors were so gross and manifold in this judgment that the only outcome on appeal should have been that the appeal was allowed. And on appeal, before the circuit judge, the judge came to a different conclusion, and that's necessarily wrong. So I can deal with it. I can deal with my submissions on the appeal judgment relatively quickly, but I've dealt with the early paragraphs 8 and 9 on the respondent's notice. The judge sets out the law at paragraph 23. I'm behind tab 5, my lords. Paragraph 23, page 44, deals with quantum, and then the judgment starts in paragraph 24, Parker Sinclair, page 47, and the judgment starts at page 49, paragraph 26. The legitimate business interest question is dealt with from paragraph 30 onwards on page 50. What the judge says at 31 is that it is a criticism of Mr. Platt's Mills, which in my submission is wrong and unfair. That what Mr. Platt's Mills was doing was subjecting the judgment to the sort of criticism which isn't allowed on appeal. We say that it's simply wrong. In my judgment, the judge says, the judge clearly held that the legitimate interest was maintaining a stable, trained workforce in which it itself had invested. That's not what the judge said. I've shown your lordships where the judge dealt with legitimate business interests, and that's not what the judge said at all. The legitimate business interest was financial that the judge had expressed, and stopping an employee using their skills.
Which paragraph of the Deputy District Judge's judgment did this one misstate?
Which paragraph is this dealing with, my lord?
Yeah.
Is that your lordship's question? I think it's dealing with paragraph 40. It says at the end. So if you look at paragraph 30 of this judgment at page 50 of the bundle.
Yes.
The judge said she was dealing with 37 to 40. 37 sets out the arguments, and his conclusion, it seems to me, is 39, 40, and 51. I've shown your lordships all those paragraphs already.
Thank you.
And then it said that he expressly rejected the proposition that the interest was preventing loss of profit, referred to paragraph 40. Our submission is that's simply not a fair reading of the judgment. That's not what the judge said. Not only is it not what the judge said, but it isn't the legitimate interest that the claimant, Geeks, was relying on. The claimant, in fairness to the claimant, and even now, is saying what it's trying to do is protect its investment. That is precisely what its purported legitimate interest is said to be. So this is simply wrong. And the conclusion on legitimate business interest is paragraph 38, page 53, that Geeks pays a livable wage, though maybe slightly below living wage, don't know what that distinction means, and offers training with a view to retaining a skilled workforce. For these reasons, 38, ground 3 fails. That's the legitimate business interest ground. It was open to the judge to hold that Geeks did have a legitimate interest in maintaining and retaining a skilled workforce. It was set out in the evidence and contended for. That's simply wrong. It was nowhere in the evidence, and it was not what was contended for. And it's not even what's contended for now in this court by the respondent. Going forwards, the judge says at paragraph 40 that the judge below didn't take into account post-contractual matters. We say that's wrong. 43, the judge dismisses the point that there was an inequality in bargaining powers, and restates the fact that it's no different to any other employment contract. And at paragraph 44, on page 54, the judge dismisses the submissions that were made in respect of the case of electronic data systems and Hubble, which I've threatened before to take this court to. And it says wrongly, my lord, at 44, my lords, that in this case the Court of Appeal was concerned only with the question of permission to appeal. That's simply wrong. That's simply wrong.
Different in those days, but it was an appeal against a summary judgment.
Exactly.
If they'd upheld a summary judgment, that would be a very, very powerful precedent. Speaking for myself, it's perfectly all right to refer to it, but all you get from it is that Lord Mustill and Lord Nichols, as they later became, took the view that it was not clear and obvious that the promissory note should be enforced.
Because that form of, my lord, yes, to everything your lordship said. I should have said that beginning, that was rude of me. But the reason why it was not clear and obvious it shouldn't be enforced is because it could potentially be a restraint of trade. Now, this is strikingly similar to the clause we have in this case. So if it's right, if Hubble is right, that this sort of clause could be a restraint of trade, and of course this court was bound by Hubble, it's a Court of Appeal decision. If it's right that this sort of clause can be a restraint of trade, then the point in the respondent's notice goes nowhere, that it's open for a judge to find that this sort of clause could be a restraint of trade. It's not obviously wrong. Can I show your lordships Hubble briefly? My Lord Justice Bean knows this case very well. It's at Appeal Bundle, Authorities Bundle, tab 26 at 717. I can deal with it quickly. Eminent Silks and Juniors on both sides. Your lordship's right that it was an appeal against a summary judgment. At 718, the terms of the employment are set out at the top of page 2, and you can see that third line down effectively on page 718, the employee agrees that the employer has offered employment to him with a clear understanding and on the condition the employee will be required to participate in a training program. And then there's another document dropping down a couple of paragraphs dealing with charges, and there's a paragraph starting three paragraphs on the bottom. The written conditions make clear that EDS operated a training scheme to bring their employees up to the standard of skill they require. And then over the page, you can see that the employee left and there was a demand for the payment and the employee demand to pay, and these proceedings were commenced. So it's factually very similar to this case. And then at 719, at the bottom of 719, final paragraph, the court said it didn't become an argument about promissory notes, but instead, the final paragraph, instead attention was focused on one of the grounds of defence raised by the appellant, namely that the arrangement of which the promissory note formed part was an unconscionable restraint of trade, and that the promissory note was accordingly not enforceable. And the Court of Appeal said in the last 4 lines of, there was a dispute about whether the principles applied. In the last 4 lines, the judges say, in one sense, the case is novel, since an arrangement such as the present doesn't fall precisely into either of the 2 categories, the cases, namely those where the covenant under attack purports to restrict the servant's freedom to dispose of his labour after employment's come to an end, and the less common situation where the court's invited to set aside a restriction which applies whilst employment is still in being. Nevertheless, there is, I believe, no need to regard this action as calling for a venture into completely uncharted territory, since the general principles governing the relationship between public interest, allowing an individual to make a contract, the corollary of which is inevitably a restriction on his freedom, and the contrary public interest in not allowing the freedom to contract to become a vehicle for oppression are clearly stated in the Macaulay and Schroeder case. So what the judge is saying now is, and this is in accordance with the Supreme Court in Harker Sinclair and in accordance with this court's judgment in Quantum, that whether it's a pre or post termination restraint may not matter. It's the same approach for either. And then at the bottom of page 720, final paragraph, the court didn't understand either counsel to dissent from the proposition that the statements in this passage were applicable to the cases of present description. And then over the page, at page 721, page 5 of the transcript, there are 5 grounds advanced as to why it was unreasonable. No equality of bargaining. The sum of 4,500 represented about half the appellant's net annual salary, strikingly similar to the current position. The shape of the bargain was distorted, with no security of employment, yet compelled the employee to carry on in service. 4th, the sum overstated the true cost, which is strikingly similar. 5th, there was no demonstrable relationship between periods fixed and the periods which would have taken the employer to recover. And 6th, the true motive, it was said, is to get their money back, not to get their money back, but to ensure persons had learned their ways, had developed skills, did not go off to use their knowledge and skills in the employment of competitors. So those were the arguments, which are strikingly similar to the current ones, my lord. And the court said it can't be determined on a summary basis. So it might be right. And that's important in the context of the respondent's notice on restraint of trade. But it also shows that the judge here simply didn't understand what was being advanced to her, saying that it was a permission to appeal, but that at the bottom of page 54, paragraph 44, Lord Justice Mustall wasn't setting out a legal test or even stating factors likely to succeed, but simply concluding it wasn't so hopeless, shouldn't be allowed to retry. Then reliance on this case is not helpful and exemplifies why the Court of Appeal says permission to appeal decisions should not be cited. So she just seems to have simply ignored that approach. And then at paragraph 50 over the page, the judge dismisses the arguments that there was no overstatement of the cost of the argument, and at 51 says that, third line down, while profit per se may not be a legitimate protectable interest, it doesn't follow that an employer cannot make an effort to fairly estimate the cost of training that goes beyond basic hourly rates. So that's an agreement that profit per se is not a protectable legitimate interest, which cuts across what Geeks' contentions are. The judge considered and rejected all the grounds of appeal, and we say fell into error in so doing. So, turning briefly, because of the way in which I've approached the case so far, I think I can do it reasonably quickly. Turning then to the grounds of appeal. First, the judge erred, both judges below erred in identifying what a legitimate business interest was. The classic legitimate business interest, trade relations, confidential interests and protection of stability of your workforce, are not what the judge found. And the latter, as I've said, is normally almost invariably protected by a non-poaching clause, which Geeks already has. Dawny Day is the leading case on the validity of non-poaching clauses. And if I can show your lordships that case briefly. Dawny Day is at tab 31, and I want, if I may, just to go quickly to page 960 of the bundle. And if I can ask your lordships to read paragraphs 46 to 48. The restraint in that case, set out at paragraph 43, is a prohibition on soliciting or enticing away directors or senior employees. Classic post-termination restraint. The key is that you may be able to protect stability of the workforce by not permitting poaching of people in respect of what the former employee knows about them. The protection arises at 47, top of the column, because of the ex-employee may to seek to exploit their knowledge, which he's gained of their particular qualifications, rates of remuneration, and so on, but not a blanket prohibition on or inhibition on an employee themselves going and leaving and competing. That is a different order. So this clause could
Well, he's referring in Lord Justice Evans, isn't it?
Yes.
Evans, paragraph 46, is referring back to Lord Justice Leggett.
Yes. In the Hanover case.
In Ingham and ABC.
Yes.
They have a legitimate interest in maintaining a stable, trained workforce. That's where that phrase comes from, I think. That is an interest which the plaintiffs are entitled to protect against solicitation and enticement by the defendant.
Yes.
So the paragraphs 44 and 46 of Dawnay Day are support non-poaching clauses.
Yes.
In principle, but
exactly.
You say they don't. They're not the basis for saying that all sorts of restraints which protect the stability of the workforce in other senses are justified.
Exactly.
Though Dawnay Day does say somewhere else that the categories of protectable interest are not closed.
I accept that.
Yeah.
But the categories do not. I've shown your lordships repeatedly where the highest courts have said what you cannot ever protect is or stop is an employee going off and using his or her skills in the workplace. That is never a protectable category, nor has it ever been found in my submission, certainly in the employment context, that a post-termination restraint based on the legitimate interest of investment alone would work. So 2 points are, if, as the trial judge found, the protection is investment, that's not a legitimate interest which can be protected. And if the appeal judge was wrong to translate that legitimate interest into what employment lawyers understand as a standard legitimate interest of workforce stability, that was wrong. Judge fell into error in so doing, but that cannot begin to justify this restraint, which doesn't protect the sort of activity you can restrain by that legitimate interest, but actually prevents the employee themselves going and exploiting their own skills and experience.
For those of us like me, less familiar with these cases, have we got Lord Justice Leggett in our bundle?
No. I can get that for you. The quote that
Oh, it's further up in 44, isn't it?
yes,
Yes.
the quote's there at 44.
Okay.
And the quote ends that legitimate interest, that is an interest which the plaintiffs are entitled to protect against solicitation and enticement by the defendant. So that is the sort of protection you can get from that legitimate interest. If your lordship wants, I can get that case over lunch.
Well, now you've pointed out where it's quoted, and unless there's something more in the case we need to see, that's probably enough, thank you.
Yes. Perhaps I can deal with it by reply, but let me just put...
Well, if you or Mr. Mills look at it over the lunch break, if there's more that we ought to see from it, you can just hand it in and Ms. Ferber can cope with it. It may be that there isn't.
I will do that, thank you, my lord. In terms of my learned friend's approach of saying you can have a legitimate interest of money being spent or investment by an employer, my learned friends assert that in respect of two cases, one Money and Credico Lambert, but perhaps I can deal with that in reply if that point is still advanced by the respondent. We say the short point is neither of those cases is an employment case. Properly analysed, neither of those cases are solely about protecting money, but are actually other things as well. And neither case deals with post-termination restraints. In fact, Credico Lambert says that a post-termination restraint cannot be justified on that basis. So the starting point is there is no legitimate interest and the judges below erred in that regard. In respect of reasonableness, my lords, may I make four or five brief and quick points on this, because I've already laid the groundwork.
You've made them already.
I've made them already. But I don't want to repeat myself.
Well, if there's anything you haven't told us, which you'd like to tell us in the next 10 minutes, of course, then do.
No. Turning then, in the next 10 minutes, if I may, to the question of whether or not it was a restraint of trade. The respondent's skeleton at behind tab 17,
Yes.
paragraph 42. to 44 take 3 points on whether or not it was a restraint of trade, saying that the judge was wrong. First is that the judge was wrong to find that the training contract was a post-termination restricted covenant and that restraint of trade applied. First point is, and if I can make a few short points about this. Firstly, Hubble says that although this sort of repayment doesn't fall precisely into pre or post termination restraints, 719, 720 of the authorities bundle as you've seen, and we say fundamentally the judge was entitled to make the finding that he did, saying that he would probably find it's post termination restraint. There is, as a matter of practical reality, no obligation to repay during employment. The debt crystallises on resignation and is enforceable thereafter. So it's perfectly legitimate and reasonable to come to the conclusion that post-termination is when the effect happens disincentivizing an employee from competing. And if he stayed, all that would happen was that the debt would be written off month by month. And we say the significant amount, almost half his gross annual salary, was a meaningful financial disincentive against termination, which has a post-termination effect. So whether it's pre or post-termination, it is a legitimate conclusion for the judge to reach that there is a restraint of trade. And the case of Hubble, apart from anything else, is authority for the proposition that on strikingly similar facts, this court would not interfere in such a conclusion. That it's not possible for this court to say, or at least let me put it in this way, it's not possible for this court to say that it is not a restraint of trade, which is what the respondent in their respondent's notice is asking your lordships to do.
What is the legal test, if there is one? Is it whether the clause is a disincentive to leaving?
Yes.
And if that's the test, does the answer depend on the amount which has to be paid? So that if it was a very modest payment or a token payment, it wouldn't be a restraint, but if it's a substantial payment, as you say this is, then it is?
There are cases in the bundle I can take. Egon's Ender is the most recent, highest formulation in the Supreme Court of what a restraint of trade is. It's a broad and flexible rule which takes account of the realities of the situation, including all the facts that I have highlighted. Let me just find the place in Egon's Ender where this is set out, my lord.
But broad and flexible and taking account of the realities in order to see whether it is a disincentive to leaving or
exactly,
to
whether it is a
something else.
disincentive against, whether it is in reality a disincentive against competition.
Okay.
Well, it's a disincentive against leaving for any reason at all, surely. And that's one of the features of it.
It is.
Exactly. If your client had given up work to look after his grandfather, say, it wouldn't have made any difference.
Makes no difference. That goes to reasonableness, my lord.
Yeah.
It prevents, it's a disincentive against termination, but of course the employee has no control over termination because he might be terminated himself by the employer. These are all factors which go to reasonableness. But what the purpose of the clause is to try and prevent you from leaving, as the judge correctly identified. So it is a disincentive against leaving, presumably, to stop you competing and using the skills you've learned elsewhere, and to retain you within the employ. So this is obviously, we say, a restraint of trade. My lord, can I come back after? I can get the paragraph where this is set out in Egon's Ender after lunch, if I may.
All
right. As Quantum says, there's no absolute distinction between pre and post termination restraints. Paragraph 60, Little Roman 7 of Quantum, page 1261, the authorities bundle, and that accords with what's said in Hubble as well, that it may be easier to justify pre-termination restraint, but in this context it's difficult to see how, especially given that there's already an obligation not to compete in the employment contract. So how can you justify an additional restraint pre-termination? But it's certainly not justifiable post-termination. The last point on this section, the first ground, is that the respondents set out the provisions in the training contract which say it's not a restraint from pursuing other employment, and the judge is finding that he could leave at any time. But that is inconsistent. Firstly, that's inconsistent with the judge's own finding that it's a restraint of trade. And secondly, obviously it's correct that it doesn't prevent competition, but that is not the test. The test is whether it has the effect of being an inhibition on competition, which is why clauses like in Marshall, the judgment of assumption upheld on appeal by this court, were not direct non-compete clauses, but they had the effect of being restraints. Secondly, Geeks says at paragraph 44 of its skeleton that the judge was wrong to say that the obligation to pay only occurs after employment. We say that's wrong. The training contract makes clear that as a matter of fact, it didn't need to be repaid if the contract wasn't terminated. The debt only crystallised on termination. In any event, it is inconsistent with Geeks' own position on legitimate interest, my lords. And if you turn to the submissions in its skeleton argument on legitimate interest over the page 187, that's where the submissions on legitimate interest start. And if you look at page 188, paragraph 53.4 says, when justifying an investment of time and money, they say it's particularly true on the facts in this case, since Geeks sought to protect its investment consistently pre and post termination. So it has a protective effect post termination. That's inconsistent with its submission. The judge was obviously wrong by saying it's post termination. And thirdly, the Geeks say if the judge found, as he should have, that it was pre-termination, he would be bound to find that it was not a restraint of trade. Well, for all the reasons I've made submissions already to your lordships, we say that's wrong, and Hubble is a good basis for saying that this court can't possibly make a decision like that on these facts. But we say that the judge's conclusions on this cannot be criticised, which presumably is why they didn't put a respondent's notice in at the beginning, why they were very late in doing so. So we say it's capable of being a restraint, and the judge correctly found that it was a restraint, and it's not a matter with which this court should interfere. There's no hard and fast rule on what is and isn't a restraint. And we say that as a fallback position, the worst comes to worst, and the court decides that it hasn't been set out clearly enough why it was a restraint. This court can't determine itself that it either was or wasn't a restraint in accordance with what the respondent is now seeking. So the best that the respondent's notice can achieve is that the appeal succeeds and it's remitted for the judge to determine again, which frankly is in nobody's interest. But the fundamental point is that it shouldn't be interfered with. My lord, I've gone a minute over my threatened time.
It's all right.
Thank you.
We'll forgive you.
Thank you.
Miss Ferber.
My lords, thank you. Let me just arrange myself.
Yes, of course.
Thank you. My lords, I'll start just by making one short point about practicalities, which is that I'm going to address you on the restraint of trade principle generally. I will say something very short about the abusive process point, the respondent's notice, but I've taken note of what your lordships have said, and I won't spend any much time on that at all. and I will deal with the legitimate interest ground of appeal. And then my learned junior, Mr. Welsh, will rise and will deal with a reasonableness ground of appeal after me.
Right, thank you.
I have about 10 minutes or so. In that time, I'm going to make a couple of broad points to take away for the short adjournment, and then I will come back and deal with the structure of my submissions more fully. The first point that I will pick up in these few minutes, my lords, is that question which my lord asked a few moments ago, which is, what is the doctrine of restraint for trade? What is the question? And I find it useful to think about it as the following question. What question did the court at first instance have to ask itself when deciding whether this contract operated as a restraint of trade? And I say that the question the court had to ask itself was, does this contract restrain its subject, this appellant, from being able to work, from being able to trade? In here very specifically, that's because this is a training costs case. That question could also be phrased as follows: does the requirement to pay the training costs restrain the appellant from working? And the operating manual, I'm going to pause, my lord, because you look sceptical about that as a question.
No restraint of trade clause ever does.
Well, that's the point, and I say, and the operating manual for answering the question whether the doctrine bites is paragraph 60 of Quantum Actuarial. There are other paragraphs that you've been taken to as well. Those deal with reasonableness, legitimate interests a little, but paragraph 60 is the paragraph with all of its paragraphs in Roman numerals, which deals with the question, what is a restraint of trade? How is the court to answer that fundamental question before going on then to consider legitimate interests and reasonableness? That's in the authorities bundle. It's behind tab 46, and it's page 1260 to 1261. There are 8 sub-paragraphs in paragraph 60. And the nub, we say, of the test of what a restraint of trade is Roman 4 on page 1261. I'm going to read it. The application depends less on legal niceties or theoretical possibilities.
Sorry, but...
That's 6.
What did I say?
You said 4. Right, 6.
That wasn't a good start. Apologies.
Yes.
6. That 6 is what I meant. The application of the doctrine, of the restraint of trade doctrine, depends less on legal niceties or theoretical possibilities than on the practical effect of the restraint in hampering the freedom to trade. And then reference is made to the Esso case. It is a question of substance, not form. Mm-hmm. That is extremely important. That is the key. This is not a rigid test, but a flexible test. Mm-hmm. And then paragraph 2 in paragraph 60, so that's the bottom of page 1260, makes the point which my learned friend has made, and which is made in all of the cases below, at the judgments below, that there are no clear limits on the scope of the doctrine, no precise or exhaustive test can be stated. The doctrine is to be applied to factual situations with a broad and flexible rule of reason, again from Esso. And again, just touching on the points in answer to that question in these few minutes before the short adjournment. The short answer, which was given in substance on the facts found at first instance and then not appealed. The short answer on the facts in this case is a simple one. This appellant was not restrained at all from working elsewhere by the training investment contract terms. The training investment contract doesn't say that he is prohibited from leaving to work elsewhere for someone else. You know, because you've already been taken to it, my lords, that it expressly states the intention as not being that. Without going to the page right now, in the core bundle at page 28 is the part of the training investment contract which says nothing in this agreement is intended to restrict you from pursuing other employment or trading opportunities. So it does not only does it not say that, it says the opposite. And in practical terms, that was not contemplated to be the effect of the contract, and in that iterative sense in which events which happen after a contract is made can inform whether it was reasonable, not whether it was reasonable, whether the parties contemplated the later events as happening. In practical terms, the effect of the training investment contract was not to restrain the appellant from working anywhere else either. And so the basic question that quantum actuarial required the court to ask, when one goes to the facts as found, which I will take your lordships to after the short adjournment, when one looks at the facts as found, the only possible answer to the question of the application of the doctrine on the practical effect of restraint in hampering the freedom to trade, the words in quantum actuarial paragraph 60, subparagraph 6, not 4, the practical effect of the restraint in hampering Mr. Watts's freedom to trade was none. It wasn't intended to have any effect. It didn't have any effect. It wasn't in the contemplation of the parties that it would have that effect. So that is the answer in my submission to the doctrine question. Does the doctrine apply at all? And as I say, I'll develop that after the short adjournment.
Can I just ask? So it's a completely different approach then between what was being said about Lord Justice Mayles. There's a disincentive of leaving employment. You're saying it's restraining the ability to work. No, I'm not saying that. Are you disagreeing with what was being said?
It's absolutely right, and the two Marshall cases before Jonathan Sumption sitting as a High Court judge and then Lord Justice Millett sitting as a judge of the Court of Appeal both make very clear that if the effect of a non-compete clause, if the effect of a clause is to stop an individual from competing, it doesn't have to say you are prohibited from competing. It can say if you don't compete, we'll pay you this money. So a disincentive effect can be a species of restraint. But what I will develop after the short adjournment is the principle that none of the cases, and you have some 30 reported cases in the authorities bundle relating to restraint of trade, not one of those cases has ever found that a pure disincentive, if it is a disincentive, from leaving this job with no concomitant non-compete condition attached to it is a restraint of trade. I'm not for the moment talking about principles, I'm talking about cases that have been decided. So there is no case decided by any court which says that a clause which purely either requires a person to pay money or pays them some money to stay in a job operates as a restraint of trade. There is no such case.
Well, that makes the case very simple.
Yes.
I mean, you could have a clause in the contract saying this is training grade job and you're really not much use to us in the first year, but if you leave during the first year, you have to repay the whole of your salary to us. Simple. And you say that that's a straightforward contract, its terms are clear, the doctrine of restraint of trade doesn't apply, it's not a penalty, therefore I ask for the usual order.
There is, we say, a residual oppression test, which is important because well, it's not because it is a separate test or anything like that, but because when one looks at the way in which quantum sets out the principles and asks that question, which I'll read it again because it is the easiest way to answer the question. What is the practical effect of the restraint in hampering a person's freedom to trade? Now, if in practice, having somebody employed for a year, but if they leave within that year, irrespective of how long they've worked, for example, I'm now taking possibilities of the way that a clause might be drafted, they then have to pay a whole year's salary, even if they've worked 1 week.
Oh,
that may well be that operates...
I didn't mean that. That would surely be a penalty. But
yes, exactly.
But if you leave during the first year, you have to repay the salary, whatever it is. If you work for a month, you have to repay a month. If you work for a year, you have to repay a year. That's very, it's very tough, but you say, so what? Restraint of trade doesn't apply.
Well, if in practical terms that doesn't restrain the individual's freedom to trade, I mean, I'm going to just touch for a moment on some of the facts here because that's a good way of answering this question, but I will develop this properly after the adjournment. This was a sector into which this appellant could not get. He couldn't get into a job in this sector, and he either had, presumably, to go and get some vocational training with no salary, with already saddled with high debts. That would have cost him money to go through college and get an IT qualification so he could then go into that sector and get that job. Or he could go and do something else entirely, or he could not work at all, or he could find an employer who was willing to enter with him into some arrangement which was to his benefit because it allowed him to get vocational training while receiving a salary in return for loyalty, for staying long enough to repay the investment that the company was making in providing him with training without getting any productive work out of him. And if that package, my learned friend used the word package earlier, and in fact it's in my notes to use too, if the employee considers that package of clauses and rights and obligations is something that he wants to take up because he is so interested in getting into the IT sector that it is worth it for him to take on that kind of debt, and may well be that because he has applied, in this case, for 50 jobs in the sector, he's aware that once he has had the training, even if he has to pay back all of his salary, actually he's going to be walking into a job paying double, and this particular package in this job doesn't require him to pay the whole salary back up front, but in 18 equal monthly payments, and he's thought about that, and he's willing to take on that deal in order to be able to get into IT without having to pay for a college course that he can't afford while not earning a salary.
Well, those, if I may say so, are arguments which I would expect you to put on reasonableness. But if you're right on the respondent's notice point, it doesn't matter whether it's reasonable or not. The submission on the respondent's notice is not that no clause can ever be a restraint of trade of a particular species. Quantum actuarial tells us that it's a fact-specific question in any case. What the respondent's notice says is that this particular contract, this trading investment contract with all of its terms, did not operate as a restraint of trade. It was outside the doctrine. That's what the respondent's notice is seeking to do, to uphold the order dismissing
to uphold the appeal judgment which dismisses the appeal on additional grounds. And so ask you to dismiss the appeal on legitimate interests, dismiss the appeal on reasonableness, but also uphold the order dismissing the appeal from the trial judge's judgment on an additional basis, which is that in any event, this particular suite of clauses, this training investment contract, was not a contract in restraint of trade for this employee. That's the basis.
But it does
of
logically
notice.
come first, doesn't it? If you're right about this, then legitimate interest doesn't matter, reasonableness doesn't matter.
Well, yes, I mean, there is the line of cases which is referred to again in paragraph 60 and I think also 65 of Quantum Actuarial about the decision for any particular court as to whether a clause operates in restraint of trade at all, and the question of reasonableness are iterative. In other words, one looks at the same factual questions in relation to both, and that those factual findings then feed into the fundamental question of whether restraint of trade applies at all, and then also, if it does, reasonableness. So it is perfectly possible, indeed it's common, for the same factual questions to both answer the question, is the clause a restraint of trade at all? And if the court decides on the facts that, on balance, it is a restraint of trade subject to justification, then to revisit those factual points in relation to reasonableness.
All right, let's resume at 2 o'clock.
Ready, people?